All right. The High Court in Makhanda this week ordered Shell to stop its seismic survey. Shell says it's disappointed with the ruling and is considering its options. Johan Lorenzen, who is involved in that case, joins me now. Very good afternoon. Thanks so much for your time on SABC News today. Talk to us about why the court was approached to stop the survey and take us through the different parts of that application.
Right. So Shell's engaged in seismic blasting off of the wild coast of over 6,000 square kilometers. What is seismic blasting? It is airgun explosions downwards into the water every 10 seconds for 5 months at 250 decibels, which of course you would think, of course, has significant impact. Shell and the regulator denied that. But our clients, communities along the wild coast, said we weren't consulted at all. We had no idea this was going to happen. And the sea is, in fact, very important to us, both in terms of our livelihoods, our culture, our spirituality, and our healing. And so they asked us to take it to court, and we brought their stories to the court, and the court confirmed that to do this kind of operation, it's not that you can't do it, but you damn better consult with the communities.
Mm-hmm. This is not the first court proceedings around this matter. Shell was given the go-ahead in the beginning of December. What happened then?
So there were different court applications with different applicants and different causes of action. The first application was brought by Greenpeace and Natural Justice, but also some commercial and recreational fishers who had actually been aware of the application originally in 2013. Now, we thought their application should also succeed. But I think the case, when you consider it with communities, was just so overwhelming that the court had to step in because there simply wasn't any consultation and the risk of impact were so severe. It's the community's very livelihoods at stake. So that's why the court stepped in here and didn't feel it was able to in the other application.
All right, what needs to happen now going forward? Just give us a sense of what can and cannot happen.
Well, what is clear is that for now, Shell can't continue with its seismic blasting under this right. Now, this was just a temporary order that's pending Part B of the application, which is going to be a final confirmation that Shell needed an authorization under the National Environmental Management Act, which they didn't have, and we say that they should have. There will also be a separate challenge, a review, to set aside the right they were relying on in the first place. So essentially, Shell needs to follow the law.
Mm-hmm. Of course, a corporation like Shell seems determined to proceed with this. They have spoken about that it won't damage marine life that much, that they have got permission. What other legal mechanisms are going to possibly stop this in the future? Or is it not okay to try and have a crystal ball to see what may happen? Well, we may not be able to find a crystal ball, but I think there are lessons we can learn from this going forward. And the first would be that this really shouldn't be done through court applications. Our team didn't sleep for weeks, and it was a massive amount of work when really the work should be done by the people's elected representatives, Minister Mantashe and others, to enforce the law. And I think what's very important out of this is that the minister seems to be under the impression that if he greenlights anything, lawful or unlawful, that's going to be good for investment. Nothing could be further from the truth. A good regulator helps companies by making sure they comply with the law at the right time so they don't get clapped in court later. Okay, let's take a look back at the year. How would you characterize the legal year that was in South Africa? And I know that's like a very big, broad question.
No, it's a great question. I think I've been so buried in my cases, I haven't been following the trends as much as I would like. But I think one of the troubling trends is attacks on the judiciary, as we see from this victory by Shell, and much as judges, two judges came to different outcomes, no one serious questioned that they were in good faith. And we carried on with our job and fought. So I think it's quite troubling, the attacks on the judiciary
around the Zuma litigation and the CR17 litigation, which is not to say that those shouldn't be looked at afresh and critically on the merits, but to suggest that rather than engaging with the arguments, to suggest that there's merely just some sort of capture or corruption without any evidence, I think is a quite troubling trend. I think generally our courts have been doing some very exciting work in terms of the Constitutional Court ordering that it's unconstitutional for our phones to be tapped and for us not to be told about it after the fact. There have been significant rulings around Muslim marriages. I think the courts are doing a lot of good things. And while I love that, I love the vibrance of the courts, I'm concerned by some dynamics. I think it goes back to the point I was making earlier that it is always troubling that the courts are doing so much when the state and companies are doing. It really highlights how little the state and companies are doing, because, again, it's not sustainable to be winning these fights in the courts. It's too much work, and So I think there are some really fascinating trends, but my sense at the end of the year is one of optimism and conviction that we really should be focusing on the fights outside of court much more than inside. But those will continue, I can assure you.
Johan Lorenzen, thanks so much for your time on SABC News this afternoon, of course, discussing that Shell ruling, as well as taking a look back at the legal year that was. It's time for a short